When I represent design firms that are entering into joint venture arrangements to pursue projects, there are a few themes that come up repeatedly, and there are a few issues that are of particular concern for the smaller of the two design firms that are getting into the joint venture. And these issues need to be addressed against both the upside that the parties are seeking and the downside risk that comes along with being in a joint venture arrangement, because it is so much different than the relationship between a prime design professional and his design subconsultant. While the law can vary dramatically from state to state, joint ventures rarely receive advantageous liability treatment in the joint business venture arrangement. Usually the default rule is that both parties are equally liable for the debts of the joint venture. So when joint venture projects go badly, it's typically both of the joint ventures, the smaller party included, that have considerable risk. While this can vary tremendously from state to state, typically speaking, both joint ventures are considered to be jointly and severally liable for the debts of the joint venture. This means that both the smaller party and the larger party could each be liable to third parties for the mistakes of the other, were one party, the one that made the mistake, or the joint venture itself, to be unable to financially cover the mistakes. I mention this because when design firms enter into joint venture arrangements, in order for them to seek the upside, in order for them to seek out the fees and the exciting work, and to keep their staff busy and to enhance their portfolio, they need to think about how they're going to achieve those goals against this backdrop of disadvantageous liability treatment. And while it's a little bit of an oversimplification, in many cases, the smaller design firm's goal is to make money, among several other goals. But a few things can get in the way. For example, the smaller design firm will have made certain assumptions about allocation of work assignments. However, if the larger of the two design firms force the smaller to perform more difficult or time-consuming activities, the smaller design firm's internal costs of producing its work product and participating in the project could rise and therefore erode its profits. Similarly, if the larger of the two design firms vests itself with all discretion to decide when it would seek additional services payments upstream, that could wind up hurting the smaller design firm if it's the one that gets stuck performing a bunch of work that it considers to be extra and the larger design firm refuses to seek an additional services fee. Similarly, if the larger of the two joint ventures vests itself with all authority to decide which charges it can add into the joint venture, if the larger of the firm charged excessive costs like its home office costs that were not specific to the project, or perhaps they are billing on an hourly basis the efforts of their in-house attorneys or their in-house bookkeepers, something that may not be fairly charged as an expense of the joint venture, that could erode the profits of the joint venture, perhaps taking away the smaller party's ability to profit, because in many cases the joint venture is going to pay its debts first and then out of the net proceeds distribute the profits to the two parties. So when design firms joint venture, they need to be thinking about not just the exciting work, keeping their staff busy, and how are they going to pursue the upside. They need to be thinking about how might those things not be realized in order to make it worthwhile for them to be in the joint venture in the first place. Because again, there is this backdrop of disadvantageous liability treatment that they have to live with as they try to seek the upsides of the joint venture arrangement.